everybody. How is everybody doing this morning? I am doing great. My name is Debbie. Welcome to my channel. We are on part 14 of the Darrell Brooks trial, the jerk that drove his mother's SUV through the Christmas parade in Waukesha, Wisconsin. Welcome, Pops V, to my channel. I don't think he's in here right now. Why do I always start burping as soon as I go live? Because I think he did that last night, but he joined last night. He's one of my friends from my my Disney stream. Look, Marty noticed. Hey, Judy. Hey, Wiggles. Hey, Marty. 34 degrees. Wow. It is 50 degrees here. I have not been outside yet. Travis has. To take the dogs out for just like 5 minutes, and he had to put a jacket on. I'm like, you do not need a jacket to just take them outside for a few minutes. Jeez. It's Florida, for crying out loud. Brooks was moved to an out-of-state facility on January 13th, due to what a spokeswoman said were security concerns. He was moved to a facility in South Dakota. The Wisconsin DOC participates in what's called an interstate compact, which allows for individuals convicted in one state to serve their sentence in another state. Good, because I was just about to ask about that, because I didn't know that could be done. The program is aimed at improving the safety of prisoners and staff. Oh, good. Thank you, Judy, because that answered a question I had. Because I thought like federal prison, you could be anywhere, but state prison, I thought you had to stay in the same state. I bet he's ticked off about that. Well, I was going to say, if he had visitors, he probably doesn't have any visitors. I don't know, his kids might want to visit him. Who knows? Hey, Carla. Okay. So, Brooks has just got done redirect on one of his witnesses. We're on the defense case. And I tried to get it at the very end. I don't know if I'm in the right spot. I'm around the right spot, though.
Statement that was just testified to the best of your recollection.
And you saw an officer run up and try
At that time, during...
I'm gonna... What? Girl, what are you doing? Get up and call the next witness, dude.
Right, good morning.
Why is Carla number 2? Y'all like the stream?
Come to the witness stand, remain standing, raise your right hand, and my clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat.
Is this a cop?
Please state your
Looks
first
like
and
a
last
cop.
name for the record, or names, I should say.
Stephen Guth, S-T-E-V-E-N.
Oh, yes, it is.
G-U-T-H.
He's already
Yes, sir.
testified. Right?
How long have you been in law enforcement?
Over 20 years.
And how long have you been a detective?
Just over 7 years.
Oh, okay, Marty. I'll let you off the hook this time.
Directing your attention to the evening of November 21st
oh,
of 2021. Do you recall?
I almost forgot. Jill, she needs prayers, guys. She's having some health issues. And, you know, she's got a couple of chronic diseases. And with her dad being sick, the stress has made her health get worse. So she's having a lot of problems right now. She's actually having some problems seeing. She can't drive. She's having like mini seizures, like tics, kind of. Is that supposed to say HIPAA? There's 2 P's in HIPAA. She told me I could say, Marty. She asked me to. She actually texted me and said, I don't think the chat cares about me anymore. I'm like, yes, they do, Jill. They ask about you all the time. They're excited when they see you in the chat. So if you can, if you have a way to DM her or text her or whatever, please get a hold of her and tell her how much you care about her, because she's going through a hard time. So I wanted to say that before we got started, because she's having a really rough time right now.
Call that evening?
I do.
And were you on duty that evening?
Not initially.
For more clarification, what do you mean by not initially?
It was a regular off day for me, but I received notification to respond to the police department for the mass casualty incident in the downtown area of Waukesha.
So at that point, I'm assuming you were dispatched to that location?
I was not dispatched. I received a
Marty, you can type while you're driving, but you can't hit the like button. Quit texting while you're driving.
Signal message. We use Signal. It's an app that's used that we can share information for investigations.
I will,
And I
Carl.
received a Signal message that this tragedy just happened.
And so what did you do from that point?
I immediately dropped my wife and kids off and responded to the parade.
And when you got to the parade, what did you do at that point?
I went to the downtown area to assess and see what I could help with.
At some point during your investigation, did you make contact with the woman by the name of Erica Patterson?
Yes.
And what was the nature of that part of your investigation?
I wanted to speak with Erica Patterson because by that point, when I made contact with our command center, they had learned the name of Darrell Brooks and had learned that Erica Patterson was the estranged girlfriend of the suspect of this investigation.
You made reference to a estranged girlfriend. What do you mean?
I don't know if I should answer that.
I think question was pertaining to the word estranged. But we'll move on.
The jury will disregard that last question, that it's been withdrawn. And the statement made by Detective Guth following that.
I'm assuming at some point you took a statement from Ms. Patterson?
I did.
Do you recall if it was recorded, written, you writing it? What was the nature of how the report was taken?
Well, her words were spoken and they were recorded, and then I prepared a report.
Did you prepare the report that same evening?
No.
When did you prepare the report?
Sometime after the 22nd of November.
Why not the same evening?
Because after I spoke with her, I wanted to go back and speak with her again.
Did you obtain any statements from any other people that may have been involved
Eventually, Marty.
with Ms. Patterson?
I did not.
Do you know, to your recollection, if any other officers have taken statements from parties that may have been involved with Ms. Patterson?
Well, the night of November 21st, 2021, I did have a partner with me, another detective.
Do you recall him talking to any other parties that may have been involved with Ms. Patterson?
Well, the detective that was with me was a female, Detective Barron.
The question was, do you know if your partner had any interactions with parties that may have been involved with Ms. Patterson?
I don't believe so.
Hold on,
but
are
I
you
can't-
specifically referring to a date certain or just in general?
I think it was clear.
I need it clear for the record,
The
though.
date would be
On the
November
21st?
21st,
Okay,
2021.
thank you with that clarification.
No, I don't believe so.
Did you learn at any point that there may have been other parties involved with Ms. Patterson?
In which incident?
I'm referring again to November 21st of 2021.
Yes.
Do you recall who those parties were?
Corey Runkle and Nicholas Kirby.
Did you yourself speak with either of those parties, Nicholas Kirby or Corey Runkle?
No, I did not.
Do you recall if your partner spoke with any of those
Which partner?
I'm guessing the female partner that you made reference to?
No, she did not.
And in that recorded interview with Ms. Patterson, what did you learn about the evening of November 21st, 2021?
Which recording?
Are there multiple recordings?
Yes.
What did you learn about the evening of November 21st, 2021 from both recordings with Ms. Patterson?
Your Honor, I'm going to object at this point, as this testimony covers ground that was very clearly covered during the state's case in chief.
I'll give Mr. Brooks some leeway. You are asking for hearsay, though, you understand that.
I asked him, what did he learn?
Fair enough. Go ahead, you may answer.
I learned several things. Initially, I think is what you were getting at. Ms. Brooks wanted to report that she was injured by Darrell Brooks on November 20th, which would have been Saturday. She stated that she met with Mr. Brooks at Frame Park, and they were arguing over the fact that she did not give him money, and he injured her by slapping her in the mouth and punching her in the eye. The next day, I went back and talked to her again, and she clarified that that actually did not happen on the 20th. It happened on the 21st, and that she got in a motor vehicle with him over the same argument. He was mad that she did not provide him with money. He proceeded to try to take her phone because he thought she was talking to other guys. Slapped her in the mouth, punched her in the eye. She jumped out of the motor vehicle because she feared for her safety and made her way back towards Frame Park. While walking back towards Frame Park, she was calling her friends, Corey Runkle and Nicholas Kirby, to come help her. When she arrived back near Frame Park in front of White Rock School, there was a confrontation in front of White Rock School with Mr. Brooks, Erica Patterson, Corey Runkle, and Nicholas Kirby, where there was some kind of shoving match. And that's when Mr. Brooks got back into the motor vehicle and took off down White Rock towards Main Street. Erica Patterson then made her way back towards the Women's Center.
You made reference to being told about an incident from Saturday, November 20th. And then stating that in the second interview, Ms. Patterson stated that didn't happen. Is that correct?
She didn't state that it didn't happen. She just stated that she didn't drive around with him on Saturday, November 20th. But she also met with him and was slapped in the mouth that day too.
If it pleases the court, I have a document here I would like to show the witness.
All right, if the bailiff could go to the state first to look at it. You may use the document camera if that's hooked up. Otherwise, the bailiff can take it to the witness.
Before we put an object, well, maybe
Let
we
me
should
see the
talk about
document.
this. Yeah.
All right, and give that back to Mr. Brooks. Given the content of that document, I'll sustain the objection, or what that document is, I should say.
Sustain on what grounds?
It's not relevant, yep, to this witness's testimony.
How is it not relevant?
It's not relevant.
You made reference to November 20th. That's what this document is talking about.
It's not relevant to the charges at issue. We can take it up later, and if need be, I'll let you recall the witness, but I'm directing you to move on to a new topic.
Your Honor, I'm gonna respectfully object to that and ask for finding the fact.
Here we go. Where is Ken?
The objection's noted. It's
I told
sustained.
him 8 o'clock.
Their objection's sustained, yours is overruled. Please
Call me
continue.
mad.
Is that noted for the record? I would like a written finding of fact.
The request is denied. Keep going, please.
Hey,
Denied on
JJ.
what grounds, on what lawful law?
Keep going, sir. It's not relevant.
Are you making a judicial determination that you don't have to answer that question as a public servant?
Sir, I've ruled on the objection. It's on the record. Please keep going.
Once again, information that needs to be known is being hidden.
It's not relevant, sir. Please
It's
continue.
very relevant. He just opened the door on that by saying November 20th.
Objection. Move to strike all of the comments made by Mr. Brooks in the last 20 seconds or so, especially with regard to any implication that he hasn't had all of the discovery material.
Objection, I never made any
Prior to
mention
trial.
of not having any discovery material. That never
The
was
jury
the
will
statement.
just disregard, as I've told the jury repeatedly, comments made or statements made by the parties, whether they be.
Yeah, YouTube finally got around to cursing my channel as well. I was like, everybody was complaining, and I was like, it's never happened on my channel. No, it's happened on my channel. Yesterday, it was every other one because someone could type and it would be in front of their name, and then the next time they typed, it wouldn't be, and then the next time they typed something, it would be. It was funny because it was every other one. Now it's, hey, Carla. Yeah, Mr. Donkey Butt is still rambling. He's fixing to get in trouble.
Lawyers or the parties themselves are not evidence, and you're to disregard them and not consider them in any way. And if the statement suggested facts that are not in evidence, you should not consider that in any way either. All right, go ahead. Your next question, please.
Fair to say that in your report you referenced 2 incident reports?
Objection, this
Grounds.
witness wrote.
I'm going to overrule
Fine.
the objection and let the witness answer. I think it might just be semantics at this point, but go ahead and ask your
You
question.
mean semantics? That's what his report says. He makes reference to two reports, 2 incidents.
2 incidents.
Yes.
Not 2 incident reports. Reports would be separate documents. That's what I'm talking about. With that understanding that you're referring to, and I think you're referring to incidents with Ms. Patterson, correct?
Yes.
Go ahead. Ask your question. I think that clarifies so that the witness can answer.
Let me back up. You wrote your own report, would that be fair to say?
Yes.
And in your report, you referred to 2 incidents. Would that be fair to say?
Just to clarify, which report are you speaking about? I wrote several reports.
The one written November 22nd of 2021.
I do reference 2 reports and 1 CAD call.
What was the last part? Cat call?
A CAD call, yes.
What do you mean cab call?
A CAD.
Cat.
C-A-D. CAD call.
What do you mean cat call? What?
That's a call for service that does not generate a police report.
And what was that CAD call?
That was a call for service near Frame Park for a fight involving potentially a domestic related incident.
Do you recall any other details about that CAD call?
There wasn't much in it because the officer had to leave to go to the parade.
Do you recall mention of a knife during that CAD call?
Yes.
To the best of your recollection, do you recall anyone recovering a knife or you yourself recovering a knife?
There was no knife involved in that incident through my investigation of the report that you have.
But it is fair to say that that's how the CAD call went out, that there was potentially a knife fight.
That's how it was initially, I believe, reported or communicated through dispatch to the officers that responded.
You made reference and I'm referring to the second interview with Ms. Patterson. You made reference in your report that in the previous interview that Ms. Patterson was not completely forthright. What exactly do you mean by not completely forthright?
She did not give me all the details of the incidents to me initially.
Do you recall why?
I don't know why she didn't.
So it'd be fair to say that Ms. Patterson had been untruthful with you in the first interview.
No, she told me she was extremely afraid of you. And that's why she didn't want to tell me everything.
Well, you just stated that you didn't know why she was not forthright.
I can't read her mind, but that's what she told me.
Dude, quit with the comments.
At any time during your investigation in regards to the incidents with Ms. Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them?
Had you seen any statements made by those two parties?
No.
Would it be fair to say, assuming that those two parties were present for the incident on the evening of November 21st of 2021, would it be fair to say that at some point they were interviewed by law enforcement officers, to your recollection?
Yes.
And you never seen any of those interviews?
What?
They weren't video recorded.
Had you seen any written statements from them or report from law enforcement?
I received a summary of what they stated
What?
verbally from another detective, yes.
So it'd be fair to say you did have knowledge of what they said transpired on November 21st of 2021.
I had knowledge of what they said, I didn't see anything, correct.
No, that's my dog.
And to the best of your
He's weird.
recollection, seeing what those two parties had said, what do you recall?
Objection.
Grounds.
Evidence, you didn't see what they said, and also calls for hearsay.
Sustained.
What did you read
Objection.
from those statements given by those two parties?
Objection, calls for hearsay.
Grounds.
Sustained.
Grounds for the sustain.
Calls for hearsay.
One second. Do you recall what officer took the Nicholas Kirby and Corey Runkle in relation to the incident on November 21st of 2021?
Yes. Yes.
And what law enforcement officer was that?
Detective Van Els.
And after that report that you wrote on November 22nd of 2021, was that the end of your investigation into the incident of November 21st of 2021?
No.
And what was the extent of your investigation after November 22nd of 2021?
Judge, I'm gonna object. Well, on the defendant's behalf, I believe here, based on some previous rulings the court has made.
Sustained.
You have a whole house full of farm animals, Marty, and it's one parrot.
And did you speak with Ms. Patterson again after filing your report?
Yes.
In reference to the incident from November 21st of 2021?
I don't understand your question.
Did you speak with Ms. Patterson after you filed your report in relation from November 21st of 2021?
No.
relation to the alleged incident on November 20th of 2021. Do you know if that alleged incident ever took place?
Objection.
Grounds.
Calls for hearsay, lack of personal knowledge.
Well, he reported it.
It also goes to one of the ultimate issues that we're will need to determine, so it's sustained.
No questions, no further questions right now at this time.
All right, thank you.
Your Honor.
All right, thank you, sir.
Every single time that they start adding crap, this happens. And for about the last week and a half, every time I open StreamYard, I get a pop-up that they've added a new feature. And then when they stop, it runs smoothly for a while. And then they start adding more features. They need to stop it. It's driving me insane. So that tells me it's not my computer, because when it levels off and acts fine when they're done with their additions, and then when they start doing more, it screws it up. I love parrots. I had a parakeet when I was a kid, and that was a mean bird. And then I had a duck, and that was a mean bird. Birds and I don't mix well for some reason. But I've always liked talking to my friend's parents. I had a friend that had an African gray, and that was the coolest bird. But I don't know. Birds and me don't mix. So what are they going to do if they don't have a witness?
Who's supposed to come in 10:30, right?
Call your next witness, please. I don't have that list right at my fingertips.
You said what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
Can I be provided that 10:30 list?
It's your list. Didn't you know when you're witness? Good Lord, man.
Does the state have that? You could pass it over. I don't have that at my fingertips.
Sure, let me try to, I have it, I'll write it up for Mr. Brooks to review, Your Honor.
Thank you. While we're doing that, if the jurors want to stand for a minute, go ahead, or anyone else in the courtroom.
Oh my God, Michelle. That's the only time that would happen to me. Birds don't like me either. I don't know why.
I accept for value in return for value this paperwork.
Thank you for everyone. Have a seat then. Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. There's a witness available. Please call the witness.
Yeah, Michelle, I'd be
That's
like,
not the witness that was intended to be called at this
I'd be
time.
like,
I understand
how
that, sir.
did I
Under
end up in a
90611, I have
Stephen novel?
the authority and the discretion on that. So please call the witness who's available.
So I'm being rushed to judgment.
No, sir, I'm trying to have an effective and efficient use of all of our time. So please call the witness.
Which is respected, but at the same time, being is that this is my time
Right,
to
I'm going to
present my
excuse the
defense.
jury for right now. I'll rise for the jury, please.
What's the difference between a crow and a raven? I thought that was just two different names for the same bird.
All right, thank you. Be seated. Mr. Brooks, under 90611, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would 30.
There's
And then
Ken.
if there were any left, I wasn't sure if there were or not.
You didn't provide me with that list,
You were advised on the record,
but
sir.
you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
Nah, that's
So
no, you
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you
That is not a
that
rush.
she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have
No.
almost
you
45
didn't.
minutes until 10:30, just slightly under that.
No, you
And
did miss it. I was afraid you were going to.
there's no reason
Waited.
for you not to call her.
Be
She's
able
on
to-
your list. She was on the listing as I understand it, the groupings of 3, Tuesday
That you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not gonna have everyone come in at one time, because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here, she's ready to go.
I'm just
She's
asking the
your
question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 90611 and other
Lawful law.
rules and the inherent authority of this court to control the order and mode of interrogation
Your Honor,
of witnesses.
why is it always so hard to just say yes or no? Is
Yes,
it lawful
I have
law?
the authority, sir.
I'm not disputing that.
Then why are
You
you
just-
I'm
asking?
not
Disputing
disputing. No, I said, I asked the question, is it lawful law?
Sir, I told you what I believe my authority is, okay?
You
If
told
don't
me
wanna
what your
reject
authority-
and note it,
You
that's
told me
fine.
your authority. I'm
objection is
not,
noted
I'm not
on the
debating your
record.
authority. I'm not,
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm gonna have the jury brought in, and that will be your opportunity to call
that's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I say I had with
Really?
the
You
last?
said you wanted to
I
raise an
said-
issue with
I knew
the
murder,
about
but I
the
What I
didn't know
said
defendant's
was, I
testimony.
might have
Unkindness.
more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard, what I interpreted was when you said I may have an issue with this witness, I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. So are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted, and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your
Not every
opportunity
other
to
one,
do
like
it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses, my subpoenas.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that from
And
the
so then
beginning.
I asked you
Your
to
Honor,
put
with
him
all
in
respect,
flux.
did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks, I
Numerous
have
times.
authority to tell you otherwise. You
I
may not
did-
like it, you
I
may
did.
disagree with
It's
it.
not
You
about
have
that.
been-
It's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I
And-
never
and
asked them to
frankly,
do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offered.
So at the end of
but-
the day,
but we expect
If
your
they didn't want to do
cooperation in
it,
that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
because
normal
if you
in a trial.
you can't
to call
put the people
witnesses
you can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment here. You
Did
keep
the
saying
state
that, sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
You don't know what
It's irrelevant what the state did. in
Did they
that
have to
regard.
do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with, we're gonna call this witness at this time,
But they're
and this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have to
and
do that?
accommodate their schedules. This is not about you, it's not about the state, it's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So here's the
with a shock
situation.
device
It is
on my
9:52.
ankle.
You don't have a
So how's I'm trying to control anything? I just want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to me how
because
that's
of
fair.
the process that has been set up to frankly help you get
No,
the
it's
witnesses
not helping me by
to
it's helping
court.
the state
And no.
by being able to say if we know the time and we know the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you
That's
asked me
not
to do,
true.
Your Honor. You
No, you
said
didn't.
yes, you did.
No.
You did. You asked me to give them my witness
Mr.
list.
Brooks,
No,
I
he does
gave
not
them
have
my
a
witness
stop
list.
device on.
Yesterday,
It's not my fault.
I'm very-
He's
It's not my
lying.
fault they weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury
call.
coming out, and I'm going to stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't
be
call
disrespectful with this.
releasing her from the subpoena.
You can't do that.
for your
Where's
lack
the
of
lawful law? But I
cooperation.
also have the Sixth Amendment
We
right.
have a witness available for you to call. I can require
It's
you
not
to
the witness
call her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or of
I'm not going to
or
play
order.
this game with you,
It's
sir.
not no game. That's
It
what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a
asked-
game. That's what
me
nobody.
explain this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You
you
think that
want
this
the
is a whole
opportunity
game
to
to me.
question-
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And
I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about. You a public servant.
Oh, dang. That wasn't even the stare down. It gets worse, y'all. But I'm not. He keeps saying, I don't understand. I just want an explanation, but then he won't shut up long enough to let her talk.
All right.
So he's fixing to have another meltdown after Erica
Go ahead.
testifies. And that one I think is the best. I
Defense
think
called
that one
Erica
is the
Patterson.
best.
And thank you. We'll have her brought in.
Since I'm being rushed to judgment.
I think that's another word he doesn't, or phrase I should say, that he doesn't understand. Because this is not a rush to judgment. Or pounding on the table or something.
Good morning, Ms. Patterson. If you would please make your way to the
I
witness
wonder
stand,
how
which is on my
many
right.
is it?
You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my
He does such a good job,
on my
though.
left will swear you in.
So proud of him.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
Oh, the one spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ERIKAPATTERSON.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here.
man was the worst thing that ever happened to her.
I'm sorry about that. 1 second, I'm trying to find this paperwork. Just had it on the table.
When you're ready.
This paperwork.
Did you print that off for me? Did you email? Did you stop?
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason. Good morning, Miss Patterson. So, what do you do for a living?
I have my CNA certificate.
Monkey see, monkey do.
I'm gonna direct your attention to the evening of November 21st, 2021.
And please don't say Mr. Brooks. Say you.
Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question?
I am answering your question.
I was referring to the judge.
I was hanging out
I
with
think I
Miss
kind of
Corey.
got a little ahead of.
You asked her what she was doing. She's telling you, stupid.
I'll let you interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
What were you doing the evening
Nervous for
of
Erica.
November 21st,
probably.
2021, before linking up with the alleged defendant?
Awesome.
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
We covered this ground during her testimony previously.
Objection and grounds. I object to that and grounds for the objection on behalf of the state.
Mr. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
The
with the-
objection is, from the state, is overruled. Do you remember the question?
You asked me what was I doing at the park with Corey? Is that your question?
Yes.
We were drinking. I was drinking Mike's Hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying the afternoon, a little bit around afternoon.
Do you recall having any phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Is that usually the name you refer to the alleged defendant by?
Nope.
What do you usually call him? This is the name I've been waiting for.
Would it be fair to say that during those phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
Oh, do they call him that because he was a junior?
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
I've dated 3 juniors. One was a
Do you
junior.
recall if you were still at the park during that time, or had
One
you
was a
moved
skip.
locations?
Still at the park?
And one was Frankie. They had it at
And was your roommate still present with
No.
you at that time?
Little
No,
Frank.
she
I don't
left.
remember now. Little Frank, I
We
think.
went separate ways. I stayed at the park, and she went her other way with her friend,
Do you recall who that friend was?
Nick.
Junior? She
I'm
is
assuming-
little thing.
Or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
And do you recall if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this a street, it's like a hill, went up there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering
Okay.
your question.
Um,
You asked her where you drove from. Go ahead.
What?
finish.
yes, ma'am. And then I was walking down the street when I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
made reference to walk back to Frame Park.
I don't know the exact street name. It was the walk back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's something going on.
Too busy trying to get to safety. Stupid. Juniors. No, juniors. I mean, not that everything.
And did you ever arrive
Jewish
back
people,
at Frame
but
Park?
Yes.
juniors.
And what did you do when you arrived back at Frame Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back across the street, and by that time, Miss Corey had walked toward us to meet up with me.
And you made reference to you calling your friends.
Mm-hmm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone. Her phone kept going to voicemail, and I called Nick's phone. He put Corey on the phone. I said, Darrell Brooks had just hit me.
I'm going to back up a little bit, if I may.
Every time he says that, every time he says, I think I'm going to back up a little bit, or let me back up a little bit, I think, yeah, if you had done that at the parade, none of this would have happened. If you had just backed up and gone down another road.
To the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. On the Frame Park, that's where I met you at. Me and you also got into an argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes.
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep.
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
Funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection, move to strike the answer and the question.
Grounds.
Lack of personal knowledge, hearsay.
Sustained. I'll strike the question and the answer for the reasons stated, or rephrase, or
So can I show the witness the same paperwork that I intended to show?
no.
And why not?
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No. Next question.
Any reason why it would be reported no incident happened on November 20th of 2021?
Same objection.
Grounds.
Since facts not in evidence, sustained.
Grounds for the sustain?
The record speaks for itself.
So, upon speaking to Detective Goof during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright, I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful, I just didn't tell him everything at once. I told him the next day, Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, like a little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
So where were you injured?
By my lip?
Objection, states the evidence.
Grounds.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Do you know if your roommate Do you know if your roommate had spoken with law enforcement about these alleged incidents
I don't
from
know.
November 20th of 2021 and November 21st of 2021?
I don't know.
Did
Is
she ever
that
tell
what
you
he
yourself
was
that she
not
was
supposed to
interviewed
talk
by any
about?
law enforcement?
I don't remember.
Is that what he was in jail for? That he got bail? Or is this a different incident?
One second. So what time did you meet up with the alleged defendant on November 20th, 2021?
I don't remember.
Was it morning time? evening
Afternoon.
time? I didn't hear that.
Afternoon.
What was the hump for, Darrell?
And what were you doing prior to the alleged meeting up with the alleged defendant?
Objection.
Grounds.
Asked and answered.
Sustained.
Grounds for the sustaining.
Asked and answered.
When?
Next question, please.
When was it answered? So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection.
Grounds.
Same reasons as the previous objections.
Assumes facts not in evidence. Mischaracterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied. Noted for the record. Next question, please.
I'm trying to figure out how something got pulled out of thin air. Interesting.
What'd you ever see in that man? You're so cute. You could have had anybody you wanted.
So it would be fair to say a child
Articulate
encounter
than
with the
he.
alleged defendant. Would that be fair to say?
Yes.
Yeah, is that the only child encounter?
Yes.
Do you have any other children?
Objection.
Has
Grounds.
nothing to do with the case. Sorry.
Hold on,
Mr.
there's
Your
been
Honor.
an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant? The child that you have in common with the alleged defendant, how old is that child?
15.
Do you keep regular contact with that child?
Off and on.
Describe what you mean by off and on.
I'll object.
Grounds.
This is not relevant.
Not relevant.
Grounds.
Sustained. It's not relevant, sir.
She answered it.
Next question, please.
Off and on, is okay?
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection.
Grounds.
Relevance.
Grounds.
Sustained, not relevant. You don't have to answer
Is he
that.
trying to smear her reputation or something? What is he doing? This is why I don't think people
Do any
should
of
be
your
allowed to
children
be
live with
their
you?
attorney.
Objection.
Grounds.
Relevance.
Sustained.
He's just none yet. That's the grounds. None
That
yet.
goes to the credibility, Your Honor, so how's it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration of that ruling.
Noted for the record, I direct your attention to 906.16, and the basis for the objection being sustained is it does not fall within the categories listed. Next question.
Is that lawful law?
Next question, please, sir.
I'm getting there. This is lawful law.
Wisconsin State Statute 906.1.
That doesn't answer my question, but okay.
This would have been a much different trial if he had gotten the judge that Rittenhouse had.
Where did you meet the alleged defendant?
Reno, Nevada.
That's another
How
trial.
long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at? In Nevada?
No.
Well,
I don't remember.
I don't remember where you met your baby daddy.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming, that would mean no contact at all via phone or anything like that.
No.
So my question would be, I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. It's not proper procedure, sir.
I'm going to object to those witness. They have no relevance whatsoever to this trial.
Yes, they do. And I'm getting to how
They've also never been disclosed to the state before this moment.
Sustained.
sustain why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Fact, not in evidence.
Grounds.
Sustained. Not relevant.
How is it not relevant?
Assumes facts not in evidence.
No,
And at
facts.
this point,
I got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, that the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury. I'll rise for the jury.
Here we go, guys.
Think you be seated?
It's all for funny. Your Honor, I find
Oh,
it.
hold on. All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want to
contact?
open up the door to the other act's evidence of
That's
you
not
using-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or
I
why she
didn't
wouldn't
question
have
her about that.
contact or not,
I didn't
you are
question her about
opening
that.
the door to that testimony. All of my
How
rulings
does-
have
how
been
does-
made to prevent
how
what
does
could be
pictures
seen
matter?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But you
unfairly
can
prejudicial.
open the door
Your
to
Honor,
that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can
have
get on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
Come on, man. Y'all know that's not right.
It
Y'all know that's not right.
then you need to immediately. When
So-
did you receive the
so that's- so
document?
what-
Hold on. When did you?
Wait.
I'm having you make an offer. But when did you receive the
Okay,
document?
but that I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
no,
misstatement of the
that is
evidence.
true.
No.
She said it herself.
No, marking an exhibit is not creating an
No,
exhibit.
not marking the exhibit. She said
We're not
that
going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
It's not
Right?
fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
want
letter?
to see
Y'all
the
want the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so
know
I gotta
when you
bring that in.
received it.
I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir. There are proper procedures, and I
Okay,
want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a
It
ruling.
threw people off the loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't even
Stop it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You
respect you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson please be excused?
Yes, you can
Richard,
be
those are
excused.
awesome.
My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And what
state-
happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess
Your Honor,
is maybe
with
to
all respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Upper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here, and now all of a sudden I can't.
And now
find
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did.
So how can you make the assumption that I'm saying?
Can I please make the record without you interrupting
Yes, you may.
me?
Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't.
But
I
you
didn't say,
Implied it, sir.
but did I say that?
You stated it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to them. I just said I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out though.
And like,
I
well,
don't
that's
think
kind
that's
of
fair.
interesting.
I don't
I don't
think
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
Words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So,
I can
you
see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of you, to kind of turn us in a direction away from what we're doing, perhaps even I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions as I heard them went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
To answer your question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter, I brought the pictures. Because I thought from
You
my
just said the letter
interpretation,
was on
I
the
thought
desk.
showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures.
Did he
They
not
didn't-
just
they didn't
say
come
the
out of
letter
thin
was
air.
on the desk?
The witness
We need the
knows that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing, and oh, this and this and that.
I
Oh,
don't think
no, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I think that was the officers who may have stated that. But I don't believe she
But-
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she
It was
said,
why.
I don't know.
It was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you,
Abuse
even if
victims
this letter's from
don't tell the
her,
truth.
these pictures are from her, how
That's
is it
part of
related
the
to her
abuse
credibility
cycle.
before the
Who
jury?
else could Who else could these pictures be from?
Don't you know who they're from? Don't you have an
I'm going to ask you point
name?
blank, did you get a letter that's
Or a
signed
letter
from
with a
her?
name?
God, what do you mean sign? No
How
one
do you
signs
know?
letters.
What's your why do you have
What
a
do you mean
belief that
nobody
they are from
signs
her?
I
letters?
have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on the
does like
on the
just
limb
a
And
here.
I'm asking you why you have
right.
that opinion.
I'm gonna go out on a limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So
No,
you've never
but he
received
Judge,
a letter
if he had been,
from someone writing someone in jail. No one is gonna when you
You're
say
not
to me,
answering my
when
question,
you say to
sir.
me,
What's
did-
the basis why you believe they're from Miss Patterson? That she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom,
Why-
could be, I'm just saying,
why
could
was
be anybody
somebody?
else.
This is
You gotta answer my question. It's
Your
called an offer
Honor,
of
this,
proof.
but you still got to understand why this is mind-boggling to me. Like how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters,
You
sir.
have to
That
put
might
on
be
the record,
through your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
They're
Yes,
from her.
you
I am
serious.
serious. I need you to
Because
answer.
they're from her.
But you're assuming
Like
that.
how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're gonna question her,
Have no fear. Justice shall prevail. The courts will decide. They say a man who represents himself has a fool for a client. Well, with God as my witness, I am that fool.
StreamYard messed me up again. Did you guys hear the clip?
absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not going to allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I gotta say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In
that
a
just
quiet
fine.
courtroom,
And everybody
yes, we can
assumes-
hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're
It
doing
is.
this tactic.
Because
try to
it's not a
go
tactic,
off
it's
of what
facts.
We're talking
It's
about
facts.
to some other reason.
It's facts.
To
Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have 2 pictures that you believe were from this witness.
that I know is from
No, that you believe.
that I know?
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. 1, because of a discovery violation. We've never seen them before. 2, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie, though.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
I object to that.
I'm not
because
done.
that's a lie.
Let him
Because at the end
finish.
of the day,
Let
if
him
we
finish.
gonna open the door
Mr.
on that. No,
Brooks.
since he want to make a record and not be accurate, so let's be accurate all on the record. Since you think you know so much,
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she
disrespectful,
was when we
interrupting.
met. We can ask that question
He is
too. Then
over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
no,
finish.
no, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back. We're just going to take an early lunch, 1 hour. We'll be back. And unless he brings that letter, and he
Don't
can
sit
show
here and try
it
to
is
think he knows what's
inadmissible,
going
he will
on.
not be questioned. And under 90611, I will
Then you gonna
declare
talk
the
about where my
cross-examination
kids- you don't know where,
closed.
You don't know where, what
Thank
happened
you.
at
We're
the
in
time
recess,
when all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Since when do they put up a big sign that says break?
Number 1, control by judge. The judge shall exercise
God, she's reading
reasonable
the
control
rules
over the
again?
mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the
Why is there
ascertainment of truth. Avoid needless consumption of time.
Oh,
Protect
he's in the
witnesses from
other-
harassment or undue embarrassment. The next section, a witness may be credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases. would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial, or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors. Prior to the court taking an early lunch this morning, a couple of things happened that I think are worth making a further record about. Going to the beginning of this morning, where it is true, I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not gonna, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury.
It's not on my end, guys.
To distract, to delay,
So if you hear it, I apologize. I don't
and
know
to
what it
call
is.
into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him.
Okay, we gotta stop there anyway so we can do the live trial. Okay, so this should redirect you. You guys know sometimes it works, sometimes it doesn't. But now we're gonna go to the Amber Alert murder trial, New Hampshire v. Am I prepared for Melissa? Oh, the hurricane. We're always prepared for hurricanes, Shooty. You don't have to ask every time. See, I didn't even know the name of it. I had to think a minute. We're always ready. We stay ready. We always have water and we have a generator. So we're cool. We're good. Okay. So Amber Alert murder trial. It should redirect you. New Hampshire v. Dustin Duran. Hopefully the sound will be better today. I think we're done with the interrogation video. That's where the sound was bad. So hopefully, well, except for the attorneys. I don't know why the attorneys don't have mics. We can hear the witness fine. We can't hear the questions that great, but hurricane. What, you don't have hurricane parties, Ken? Okay, I'll see you in a few minutes, guys.